So this final panel is being moderated by Peter Karol, who is an associate professor of law and director of the International Property Concentration at New England Law, Boston. And you can read his full bio, but I thought your recent article is very interesting and pertinent. His recent article in 2017 explores the threat that copyright termination rights pose to the museums and private individuals who collect reproducible artworks, not limited to a single tangible art object. So, Peter?
Thank you, and many thanks to Katy and Sharon for putting on what I think we can all agree has been a terrific, productive, and truly unique, I won't say original, conference. Our final panel today is entitled Back to the Future, and I think it forms a fitting end to the conference. We're going to be offering the most ancient and most current takes on this concept of authenticity today. We'll be reaching back to antiquity, also looking ahead to newly emergent legal venues for authentication, which will be exciting. And we'll have Lincoln. I wasn't quite sure how to fit him in. But before turning to these panelists, our esteemed panelists, I did want to point out one minor thing that just occurred to me last night that might be of interest to everybody. The term recast actually does appear in the US Copyright Act, and it does so exactly once. In particular, it shows up, oddly enough, in the definition of derivative works. So in the US, like in many other jurisdictions, copyright ownership includes a bundle of rights, including what we've heard a lot about, which is the right of reproduction, the right to reproduce something. It also includes the right to create derivative works, however. So we know that derivative works are different somehow from reproductions. How so? Well, among other things, a derivative work is defined as a work based upon one or more pre-existing works, such as a translation, musical arrangement, etc., or, and I'm quoting here, any other form in which a work may be recast, transformed, or adapted. So, in other words, under the US Copyright Act, recastings are literally categorized as a type of derivative of an original, which is something different, or even, to use that word, transformative in some way from an original work. Now, I, of course, don't mean to suggest that the Act is authoritative in any way in the way we're going to be talking about things, but it certainly does put this whole idea of recasting in an interesting light as sort of something materially other than the original, at least to the framers of this US Copyright Act, which is the law that's been shadowing much of what we've been talking about today. So with that background, thought, I want to turn it over to our panel. So we're going to start today with Henry Duffy, who is curator of the Saint-Gaudens National Historic Site. He holds degrees from Drew University, Clark Institute in Williams, and Rutgers University. He has held museum positions at the Met, the New York Historical Society, the National Trust for Historic Preservation, and the National Park Service. He is a frequent lecturer on subjects of 19th century architecture, art, and culture, and has been a contributor to PBS, A&E, and most importantly, ESPN.
Usually everyone wonders, how does the sports network get in with art? But it did in that case. But anyway, so after all that, let me just see if I know how to run this little gizmo here. Oh, look at that, I do. I'm going to be covering about a century of time, but I know it's late, so I'm not going to take that much time to do it. So it'll move along. What I'm starting with here is the thing that we've been talking about, the mold. You see a photograph there of a piece mold, and I wanted to start with that because we haven't really actually seen what it is that we're talking about. A piece mold is the method by which sculpture has been made for centuries. It's made of plaster because plaster is one of the few materials that will stand up to the temperature of bronze, which is 1400 degrees when it's poured into the mold. And you see it's made of tiny parts, small parts, that's the pieces, like a jigsaw puzzle that are corresponding to each surface or area that you're trying to duplicate. So on a face, of course, you're trying to do the forehead and then the spaces in the eyes and around the nose. So each of those needs a separate piece. And it's all held in a large outer section called the mother mold, which holds it all together. In my instance, I'm talking about the molds made by the artist Augustus Saint-Gaudens, whom you see here at his last studio in New Hampshire with his wife, who plays a major role in my story. Just to remind people, I've illustrated the two pieces of Saint-Gaudens that are most easy to see in Manhattan. The first of his major monuments is the one on the left, the monument to Admiral David Farragut, which is just a few steps up in Madison Park. And the other one is at the base of Central Park, the monument to General Sherman. Saint-Gaudens was not American, he was Irish, came here as a child, worked primarily in New York. His family was, again, just blocks from here on 22nd Street, but on the west side, just a few blocks from here. So we're in his territory here. So I better do this right. He is known mainly for Civil War monuments. He also designed coins, medals, jewelry. He was an organizer of events, of organizations like the National Sculpture Society. He was a teacher at the Art Students League and other places. He's interesting as a 19th century American artist because at his death, because he had worked simultaneously in Europe and America throughout his career, he was one of the few American artists to be internationally known. There were several services at his death. He died very young at the age of 59 of cancer. One of them was here in Manhattan, but the main funeral was in Washington, and it was essentially a state funeral. President Roosevelt was the principal speaker at it. It was attended by the diplomatic corps, the congressional representation, and so on. I can't think of another American artist who was afforded an honor like that, certainly at that time, and I don't know since, to have what is really a state funeral. Which is just to give you a sense of who this guy is. At his death, his wife, whom you see on the right here, Augusta, was thrust into the control of the studio. That happened not at her wish, but by circumstance. The heir to his studio should have been his brother Louis, who was also a sculptor. Louis was unable to do it. Louis walked into the studio after his brother's death, looked around at the people working, and said, "This all has to stop." Well, you know, there were about 15 to 20 people employed there. So what does that mean? So someone thought to go next door to the house, and if you look at the bottom right picture, you see how close the studio is to the house, and you see Mrs. Saint-Gaudens there going back. Someone went over to the house and told her. She ran over and said, "Ignore that. You all have jobs. Continue on with your work." And in that moment, took on the control of the studio. She did it well. She proceeded in a very organized way to try to amass all the molds that she could, make plaster casts of all of his works. You can see what survives of it on the left there in our facility now. The collection is about 10,000 objects. There's about maybe 7,000 or 8,000 molds. So she did well. The larger pieces that she couldn't find molds for, she had recast. And she had them recast by the studio, by the members of the studio. So the same people who made the first one for the artist are making another one for her. You can see the standing Lincoln here in the studio, monumental scale. The original one dedicated in Chicago, but she had this plaster one made. And she had these plasters made for control of she wanted to get all of the artist's work in one place, but she also did it for marketing purposes because she organized a series of traveling exhibits, the first one being here at the Metropolitan Museum. But she wanted to make sure that these things would continue to honor her husband. Because she began the process of making casts, that was continued on after her death by the private foundation, the Saint-Gaudens Memorial, which she and her son Homer founded. Homer, by the way, was the director of the Carnegie Institute in Pittsburgh, so had some museum experience as well. But when the National Park Service took over from the management of it from the memorial, we have continued to try to amass the moles that we can. There have still been some that have been able to be found. And we were very careful in the recreation of works of art, so that we only did so in the case of works, as Mrs. St. Gaudens did, which were not available to us, so monuments. The one that was specified in our scope of collection as the one that we really wanted to do was the Lincoln in a bronze version, full-scale bronze version, which you see down in the lower left there, which was just dedicated in 2016 on the 100th anniversary of the National Park Service, the 50th anniversary of the park. That's the only monument that is in our scope of collection now to be so duplicated. We won't do any more. It's done for display purposes, for educational purposes, not for sale. It's done from the original plaster, which you see being worked on up above there. The process took a decade to do, raising the funds. The plasters had to be restored first, and then the bronze assembled. You see it being assembled on the right there at the in Gettysburg, at the National Park site in Gettysburg. So this was done with care, done to bring this to the park, and there's a specific reason. The Lincoln was the only one of St. Gaudens' monuments to be made entirely in Cornish. So we felt it belonged there. And also, the monument itself played into the story of the formation of the park itself in 1964. There was a drive to make better relationship with our southern neighbor, with Mexico. And President Johnson wanted to give a gift. And the gift that was determined to give was a figure of Lincoln. They used the St. Gaudens Lincoln in Chicago as a model. They took a cast of it, duplicated that, and made a bronze cast, which was presented to the government of Mexico. That happened in the same year that the park legislation came to Johnson's desk, and he signed it. One other thing was the presentation in the process of that of a bust of Lincoln's head, which you still see in pictures of the Oval Office. Once in a while you'll see it. It's still there. At the presentation of that head of Lincoln, Johnson used that moment to unveil his civil rights agenda. So there's a lot of reasons why we felt that this Lincoln belonged here. Mrs. St. Gaudens' process of very careful control of her artist husband's studio and the presentation of the molds, she made additions very carefully, again using the same artists, the same studio members that he did to make them, and she fussed endlessly about patinas and so on. That process of a widow doing that kind of thing continues, of course, as we've seen. This is another example. I think one of the best programs we do at the park is to have a sculptor in residence every year who demonstrates the process of traditional sculpture to our visitors so they can see it. One of the most popular of these sculptors was a young man named Lawrence Nolan, whom you see here. He came as a student to us, and he continued on, stayed and followed his career. Unfortunately, as in the case of Saint-Gaudens, he died very young, at the age of 48. And one of the things that we haven't talked about so far is that there's a certain necessity to continue certain things. The figure on the right is a figure of Christ that was in his studio, ready to be sent to the foundry when he died. He was just doing the final crisping up of the details on the clay. And despite the fact that he had just died, the client still wants, there's a contract. The client still wants the sculpture and was asking for it a little too soon. I mean, I was involved with this as a friend and advisor to the widow, but because Larry had been a friend of mine. But I had to tell them, give a little distance, please, because of course there's an emotional side of the thing. The man had just died, so I said, don't be bothering the widow with the contract right now. But they wanted it, so it had to be finished, and it was finished by his foundryman who had worked with Mr. Nolan through his career, who was able very carefully to crisp up those clay areas, particularly in the face, being very careful not to make any change to any of it, but to just make it sharp enough that it could go to the foundry. I should say that the widow also made some marks on it, some changes to it, and even the children did, which is a kind of a sweet story in a way. The children were 6 and 4 at the time of their father's death, so what they made was not much of a contribution, but it was just the idea of the thing. But it's another example of how there's the notion that we've been talking about, but there's also the practical side with Mrs. Saint-Gaudens, with Mrs. Nolan, with others that we've been talking about, that there's a family that needs to eat, and they need to do something. In this case, I know that Larry had said to me, and I wondered afterwards why he said it, perhaps with some prescience, I don't know, but he had said that he wanted his wife to get every conceivable benefit out of the studio that she could. That's interesting in the light of what we've been talking about. But this brings me to the final part of my story, and I'm about to wrap up here, but we wondered at the park whether there was a way to get access to the molds that were in our collection that were sealed. It's common that an artist will seal a plaster mold because there's parts, so you don't want them to get lost. So you'll put them together, you wrap a cheesecloth soaked in a liquid plaster around it, it hardens, and that's left. We had in the collection probably 20 or 30 of these of varying sizes. Last winter, our director, Rick Kendall, contacted the radiology department of the local hospital to see if they would be interested in attempting to scan these things, to see if that would work. And Jocelyn Chertoff, the director of radiology at Dartmouth-Hitchcock, agreed. Now, this was more involved than you might think. We're familiar with scanning solid objects. It happens not all the time, but it's happened numerous times. That's not new. What was new in this case is trying to scan an empty space, because these are molds that have nothing in them. So would this machine read an empty space? We didn't know if it would. We tried. What you're seeing here is the setup of it. What shows up on the screen in the program. You see the mold on the machinery behind it there, and you can see that it did in fact give us a image. And what's more, the white lines that are scattered through it are the metal armature. Again, we didn't know if that would work, because metal in those machines tends to spark, and we thought, is this just going to give us trouble here, to have, burn down the place, then we'd be unpopular. But no, it didn't. It worked. And I should say also that because this is a working hospital, Rick and I were dragging these things over here last winter very early in the morning because we had to do it before the hospital opened to the public, which is at 8 o'clock. So we were there pretty early in the morning. But it was worth it because what we found were elements that we didn't know. Some of them, here's an eagle from the Brooks Monument. We didn't know we had a cast of that, but there it is. The image on the left is what comes up on the machine. It was then sent to their imaging department, and we we had a kind of a funny conversation, the first one, because the woman who was getting this is used to looking at body parts, and she saw this come, and she called up and said, "What am I looking at?" And we had to say it's a work of art, But anyway, it was her job then, in her skill set, to create the images you see on the right there, which it gives us a better indication than the kind of X-ray image that we had on the left. We then began to see that we had other images from this monument, and the hand is up on the right. So the raised hand is the one you see on the left, and this little funny thing is a piece of the drapery on the pastor's robe there. This is the Brooks Monument in Boston. Again, we didn't know they had these parts. Again, we learned things. Look at the fingers on the hand there, and you'll notice that the top ones look funny. And what this teaches us is that when Saint-Gaudens was making the clay, he worked with tiny little nuggets of clay that he would roll together and put together to form the finger. Not just, a kid would, make a sausage, but he didn't make that. So we've again learned something about Saint-Gaudens that we didn't know about his technique. Here's then again the third part of what we did. The IT department at the hospital had someone who was familiar with 3D printing. So he was able to take the image that you see up on the top right there and turn it into a programmable image that he could put in the 3D printer, and from that come up with a little solid object that you see here. And this is the most interesting object that we found, because this is a portrait that was previously completely unknown by Saint-Gaudens. This is the only example of it that's ever been seen. We have no idea who this guy is, so if anybody recognizes him, let us know. But it's wonderful. I mean, we really had no idea who this dude is, but anyway, there he is. And so the process of taking it from the scanning to the imaging to the solid allows us to really move forward in a way that is quite amazing. And this is where I'm ending. This is one of the images of a head of Lincoln. Look at the amazing detail of this, that it captures every tiny image, process, every little nook and cranny. So with this technology, one will be able to learn about a sculptor's method and a sculptor's process in a way that we were not able to do before. So thank you for your attention.
Thank you, Henry. So up next we have William Charron. Bill's a litigator who co-chairs Pryor Cashman's art law practice. He represents institutional and individual clients in a wide range of art authenticity, title, and other matters. He has extensive experience handling intellectual property litigation with copyright, trademark, right of publicity, and defamation matters. He's a frequent speaker and writer on issues impacting the art world, such as authenticity disputes, World War II restitution cases, artist royalty rights, and procedural law issues. He's an advisory board member of Authenticity in Art, AIA, based in the Netherlands. I think we're going to talk about that a little bit today. And a founding board member of the Professional Advisors to the International Art Market in New York, and a member of the City Bar Association's Art Law Committee. So with that, I'll turn it over to Bill Charron.
Thank you, Peter, and thank you all. This is my third time speaking to this group. The last two have been focused quite a bit on authenticity problems, some examples, cases. Today I'm here to talk about, hopefully, a potential, maybe not a solution, but a meaningful step towards a solution, particularly involving authenticity issues, but also involving art disputes in general. As Peter mentioned, I'm an advisory board member of Authentication in Art, or AIA, in The Hague. And every 2 years, AIA has a congress in The Hague, gets a good cross-section of people from the art market, and the objective is to really kind of observe and best understand the problem. So there's a lot of discussion and a lot of pointing out of what all the problems are. But at the last conference, we started moving towards an initiative that I'm very close to and I've been involved in now for the last couple of years. I think one of the biggest problems I've seen in the art world vis-a-vis litigation and dispute resolution is the deciders themselves, the courts and the juries, which are just not very well equipped to decide these issues. From the technical, which can be very complex, to just market-based understanding and how to weigh the evidence that is presented. So for instance, in an authenticity case, if you have a world-renowned connoisseur of an artist who is offering an opinion that a work is authentic or not right, and a court comes down opposite to that opinion, not because the court's just out of its mind, but because the court is constrained by its own rules of procedure, in this country, due process. And so courts are reactive bodies. They're not necessarily there to find the truth. They are there to weigh the evidence that is presented to them and decide who, more likely than not, is right. And so you'll find these decisions where a court will say, well, you know, more likely than not, we think it's right, even though the leading connoisseur says it's wrong, or sometimes even the artist himself may say it's wrong. And so you go to all this trouble and difficulty to get a result that the market just won't accept. And so I call this a learning curve problem, except the learning curve sort of goes like this. It's not ever really leveling from what I'm seeing. And it's created a whole bunch of collateral problems. One, which I know is near and dear to this group, is that it has had a severe chilling effect on scholars and connoisseurs' willingness to come out and offer their opinions because they are afraid of being sued, and rightly so. It has happened. There are very, very few instances of successful lawsuits, but it doesn't stop people from bringing them. And so, you know, better to just keep your mouth shut than to run the risk. There are ways to protect yourself. I've spoken about those at past conferences. But this is unquestionably a collateral damage of the deciders not being able to handle and process these cases perhaps as properly as they should. Another collateral damage is just the inefficiency and the very high cost of these kinds of cases. It is not the rare case, particularly in authenticity matters, where courts are really at sea. They don't know, and they're being put in a very difficult position. And so their instinct is bring in as much expertise as possible. And that's great if you're a judge sitting up on a bench. It's not so great if you're the party that has to pay for the experts to come in and do all the work. Now, in the case of scholars, a lot of times they may not accept any money. That's great if you're the litigant. But when you have to bring in scientists and do forensic analysis or even provenance researchers, the costs can really go up. And then the other side's going to have their own expert. And they're going to battle it out, and then the costs are just going to go up more. So the inefficiency and the cost is another problem. And then third, as I mentioned, is that once you get through this morass and you've made it through after a couple years, a few years, 10 years of litigation, the market says we don't care about the result. So congratulations. So what are we going to do about that? We decided at AIA that what we should do is see if we can form kind of a better railroad, a better forum to handle these kinds of cases. And that is resulting in what is being called the Court of Arbitration for Art, or the CAA. It is being launched formally at the next AIA Congress in The Hague on June 7th. I invite all of you to attend. But it's actually a bit of a soft rollout right now. You folks being the very first group, I'm very privileged and pleased to introduce the newly codified rules, which I'm going to walk through in a moment, which were just published as of April 30th. And so you all are the first ones to get a sneak peek at this. Just to explain, before I go into the rules, to explain how they came about. So again, this largely came about because a couple of years ago, I was, looking around and thinking maybe if we improved the forum, the idea of AIA, you're not going to eliminate the problem of fakes and forgeries or art crime in general. If there's money to be made, there's crime to be had. You're not going to stop that. So AIA is about surrounding the problem, and so we bring in experts of all kinds, and this is just another way to do it. The objective here was to create a forum that would provide both market legitimacy and decisional accuracy. Those were the two overriding precepts at each step of the way when we were asking, will those objectives be met? And again, the idea was to get deciders who are well-versed and experienced in these kinds of cases, and in particular the evidence presented, so they know how to evaluate it and weigh it according to not just a legal dynamic, but a market-based dynamic. It's also involved, what we want to do is unseize you folks, get you to come out of the shadows and start offering your opinions. I have referred to this quite regularly as a market imperfection or a market failure, when you've got the best quality of evidence, meaning the connoisseurs, unwilling to speak. That is a serious problem. And so one of the objectives was to provide a safe environment, an environment where experts can feel completely protected to render their opinions with complete indemnification. And the last objective was to provide transparency. Arbitration, for those who may not be familiar, arbitration is a form of what's called alternative dispute resolution. So one way to battle out is to go into a courtroom, which is public, and your filings are public, and the public can come into any courtroom on any day of the week and just listen in to what's going on. Arbitration is private. And so particularly for the art market, which prizes, in a lot of cases, privacy and even anonymity, arbitration provides, or alternative dispute resolution provides a safer environment. The complication we had is that we want the market to know about the results. It can't be, the proverbial tree that falls that no one's around to hear. That does no good. And so we had to figure out a balance there. And I'm going to get to that in a moment. What we did was I formed a very small working group of fellow art lawyers in New York, and the four of us spent the last 2 years. We canvassed a lot of the stakeholders for this group. Some of you might have even responded. I sent around a questionnaire about a year ago looking for anonymous responses. We did a literature review. We compared other specialized courts around the world. And we came up with the Court of Arbitration for Art. So with that, this is going to be very difficult for you to read, I see. So I'm going to read it to you. I'm going to highlight a few of these. So what this is this is implemented by a group in the Netherlands called the Netherlands Arbitration Institute, or NAI. It's a highly respected ADR, Alternative Dispute Resolution Tribunal in Europe. It's equivalent to those of you who may be familiar with the American Arbitration Association, or JAMS in the US. They are up and running. They are implementing this Court of Arbitration for Art as an adjunct to their processes in combination with AIA. And so these are the adjunct rules that my working group spent the last couple of years putting together, and then this is the codified result. And so just a few that I'll point out. One is, they refer to the rules as points. Point 4 regards the arbitrator. One of the questions we had was who should be the deciders? You know, the reflex of a lawyer is to say, well, it should be a lawyer. But of course, the danger there is that you look like it's just going to be a lawyer's employment program. So it needs to be justified. And so we considered, you know, should scholars be arbitrators? Should scientists be arbitrated? And what we decided, drum roll please, is that the arbitrators should be lawyers. But there is a reason for that. And the reason is that the art world, as we all know, it's small and it's flat and it's smaller and flatter all the time. And these cases, I heard in the last presentation, there was a question about, you know, choice of law, copyright law. Was it Italian copyright law or another jurisdiction? These are serious issues that come up, and people have a right to litigate over which law should apply, how to interpret it. There can be a lot of what are called time-based defenses, like statutes of limitations, which come into play when evidence has disappeared, when claims haven't been brought over the course of decades or maybe even centuries, and so there are no witnesses, there are no documents. How do you effectively litigate that? And it's not fair and not reasonable to either non-lawyers or the litigating parties to put non-lawyers in the place of the deciders, because somebody's not going to get their fair day in court. They're not going to be heard. And one thing that for an arbitration award to be enforceable, at least in this country, is it must satisfy due process concerns. It must hit a minimum due process requirement. And so the ability to be fairly heard was important. And so the arbitrators will be lawyers. The panels could be anything from 1 to 3 arbitrators. Parties may decide to just have one. Arbitration is a matter of contract. You can never force parties to arbitrate. So the parties to the dispute need to agree as a matter of contract to do so. Oftentimes that is a matter, and this is you know, another reason that I'm excited to speak to this group. It can be in the form of a submission agreement for an authenticity opinion to a foundation, or auction houses or dealers in their standard contracts often have dispute resolution provisions. And so if they have an ADR provision, if they have an AIA ADR provision, then the parties are agreeing to do this as a matter of contract. And they can, once they do that though, it does cost money. Litigation, we believe, will cost exponentially more money, and the point of arbitration is to streamline these cases and make them much cheaper, but you still do need to pay for the arbitrator's time, you need to pay filing fees, and you do need to pay for experts, which I'll get to in a moment. And so you could have one, or you could have a 3-arbitrator panel. The point 8, place of arbitration, the arbitrations are deemed seated in The Hague, which is to say they are acknowledged for legal purposes as emanating from the Netherlands, but parties can conduct their hearings anywhere in the world. So you can have an AIA arbitration or a mediation in a conference room in New York or London or Berlin or wherever you'd like. Now to the more substantive. Point 10 regarding experts. So this is one of the more unique facets of what we've come up with. In typical litigation, as I indicated, it can often be a battle of experts. One side's got their expert, another's got their expert. They're supposed to be neutral. They're not supposed to have any stake in the outcome. But they are being paid by a client to render an opinion that is favorable to their client. And so they are effectively advocating their expertise. And it can become contentious, and it can become a litigation within a litigation. And that is an important dynamic. It's sort of, you know, as Churchill might say, it's, you know, the worst structure in the world except for all the rest. But what we've decided is, with respect to authenticity disputes, there are 2 forms of expertise that will not be subject to dueling advocates. Those are forensic analyses and provenance research. For those 2 kinds of expertise, if they happen to be warranted in a particular case, and every discovery plan will be on a case-by-case basis, then there will be pools of internationally recognized scientists, bless you, and provenance researchers who will be selected by the tribunal. They will be experts for the court. And the parties will be able to have their own consulting experts. They'll be able to examine them, cross-examine them. And the experts will have both the right and the obligation to go back and correct any errors that might be pointed out or do supplemental work. And the idea is to make them feel more comfortable so they don't feel defensive about if they did miss something or if a cross-examination does point out something that might be done in addition. And so we think that with respect to those two areas, the market will be more inclined to accept the results, that this is not just the function of perhaps one expert argued better than another or appeared better, was able to testify more persuasively in court. The idea is to get it right. And there will also be in this country, they're called magistrates, but it's referred to in point 12 as a technical process advisor, someone who will be there, typically it'll be another scientist, who will help the arbitration panel understand what discovery is really warranted in a given case, so that discovery just doesn't go off on a complete tangent and again cost considerable amounts of money. And then point 15, publication of the award, is the last rule I'm going to point to. Actually, I'm going to point to two more. Point 14 is substantive law. So as I said, a lot of times you can have these battles over which jurisdiction's law should apply. And what we decided was parties can always be free to select their own law in their contract, so they can say up front, we're going to agree to arbitrate this before AIA, and we're going to agree that New York law will control. And that will be binding on that arbitration. But if the parties don't do that, then rather than have a litigation just on the question of choice of law, which I can tell you in a fairly well-known stolen art case I litigated in New York, took 4 years just to litigate that issue. We decided to have a black line rule that it's actually point 13, the law of the principal location of the seller of the art at issue, if that location is known at the time of the transaction, will apply. And if you don't know that location, or it just doesn't seem to apply, then it will be the law of the owner of the object in question at the time of the commencement of the arbitration. So parties will have their eyes open to this reality going in. They can opt out if they want, but it'll provide certainty. Right below that, point 14 deals with the time-based offenses that I mentioned, statutes of limitations and the like. Those will also apply if they govern in a particular case under that law. A lot of times arbitrators are free to disregard statutes of limitations. In this case, we decided that these defenses are so prevalent in art disputes and so important that we wanted them to be respected. And then last, point 15, publication of the award. So as I said, the proceedings will be confidential and private. Members of the public can't just walk in. The filing of a complaint or an answer or a motion will not be publicized. But when the arbitrator renders the final decision, that must be both a reasoned decision, so it cannot just be a one sentence, I find for the plaintiff or I find for the defendant. There needs to be an explanation of why that party wins. And while the party names will remain anonymous, and we will maintain anonymity for all dynamics of the case in general, the work of art will be published. Because again, we need the market to know and accept that if a work comes out and there's been a finding that it wasn't stolen, or a finding that it's authentic, that the market knows about it and they know the reasons why. And as I said, the idea is to instill enough confidence in this process that the market will accept, well, if AIA found that this was authentic, then that's a very good ruling. And so that's a quick introduction to the new Court of Arbitration for Art. You'll start to see some press releases coming out about it. And certainly can get links, and I would welcome anybody's welcome to reach out to me to learn more about it. But I would encourage all of you to keep it in mind. Again, you are the front lines on not only the ability to provide expertise, and you will be contacted by AIA on a case-by-case basis if your artist is at issue. You will be invited to participate. I hope you seriously consider it and do participate as an expert. But also, it's your submission agreements, your contracts that can control whether these disputes go to open court and all that that brings with it, or goes to something like AIA. Thank you very much.
Thank you, Bill. Very exciting to be the place to unveil that news. Okay, our final speaker is Daehner. He's an associate curator of antiquities at the J. Paul Getty Museum in Los Angeles. He holds a PhD in classical archaeology from the Pryor University in Berlin. His dissertation on male nudes in the 5th and 4th century Greek sculpture was published by the German Archaeological Institute in 2005. At the Getty Museum, he curated several exhibitions exploring the history of archaeology, Roman imperial portraits and their modern copies, as well as the role of ancient art in 20th century European modernism. And in the interest of time, I'll leave it there and turn it over to Jans.
Thank you, Peter. Thank you, first of all, and again, to Sharon and Katy. I feel it's kind of a privilege to close this, I can say now at the end, I think, very successful proceedings of the last 2 days. I'm not so sure how I feel about that you actually put me up here, literally surrounded by lawyers. But after what William just told us, I feel a lot better, I'd have to say. Make me feel more comfortable. I also wanted to proceed. Oh, I have to advance it to my first slide, I guess. It's just the title. So that I don't have, really being the outlier in this program, have a kind of a nice case studies in the mold of what we've heard over the last 2 days. But I wanted to highlight a few aspects when it comes to the study of ancient sculpture, where I see important, intersections, or rather, significant differences. And terms like, so I went along looking at key phrases of our event, including Afterlife, including Posthumous, and sort of other, terms that are actually kind of foreign to us ancient art historians. We think of almost every ancient sculpture as something that is, an expression of an afterlife of some original sculpture of the Greek period that doesn't exist anymore. So I point out a few of those issues, and you can then see how this applies, or in many cases doesn't, to people working with living artists or with artists like that still under copyright. I hope I stay clear of mostly legal issues, and there's really not much, copyright is not an issue at all in the ancient world, thankfully, or depending on, like, if you need more lawyers employed, then too bad. But I start off with one. This is a kind of case study. This is what we call a herm, kind of abbreviated form of statue, basically a bust with mounted on a shaft. And I only noticed now that there's an important part missing. An important part missing here. This is like a phallus that goes in the middle of the shaft. Has to do with functions of this being an apotropaic, object, or symbolizes something to ward off evil. It does exist actually in case of this bronze, and but it's just in this image somehow is retouched. I have no idea why it's not there. I noticed it too late. So this is an object that a bronze, mostly I'm talking about bronzes, and if not, then I point that out, that was found in 1907 in a shipwreck, and that was discovered off the Tunisian coast, and it's named after the shipwreck was named after a site, Mahdia, on the Tunisian coast, with other bronze sculptures and marble sculptures. And the ship has been dated based on the cargo to about 80 BC. It was traveling most likely from Greece or somewhere the Eastern Mediterranean to Italy, and it had full kind of set of, kind of luxury decorations, furnishings for Roman villas, including artworks already at that time, at 80 BC, to be considered antiques or antiquities, like this one in particular. And what is very interesting about this object is it actually has an inscription. An inscription includes the name of an artist. And that's something that's extremely rare in antiquity. First of all, large-scale bronzes are very rare in ancient sculpture. And I come to the reason for this later. But this is, I believe, just one of 3 large bronzes that has an artist's name attached to it. I kind of hesitate to call it a signature per se. But you can, sorry, go ahead. This signature here enlarged is basically on this kind of arm boss, to the side of the shaft, and it's made by little sort of like with a punch, with little dots, I believe, after the cast of the bronze, but I'm not totally clear on that. And it names one Boethos of Chalcedon, who we know from other inscriptions, not attached to artworks, but from stones or a statue base or somehow, and therefore in the literature. And so we know that he was active in the 2nd century BC, among other places on the island of Delos, and known, of course, mostly for its sanctuary of Apollo. The bottom of this shaft contains kind of a big chunk of lead, which indicated that this piece had been previously mounted and installed. So being on this ship meant it was shipped to somewhere for some, repurposing or recycling, which is very common, particularly when it came to bronze. And there was an emerging market, particularly for Greek antiquities. I mean, I call them antiquities already at this point for Roman patrons, including those wealthy villa owners who wanted to equip their properties and gardens with Greek sculptures, and the most sought after were original Greek sculptures. So this could have been a piece that was originally placed, or would have been very likely originally placed in a Greek sanctuary, and then was being looted or legally sold for Roman patrons in the Western Mediterranean. And we know this because the rest of the ship, as I mentioned, of that cargo, included similar objects. Now, in 1979, the Getty Museum, my museum, bought a herm made of bronze that looks surprisingly similar. Surprisingly, in so far as that we're looking at bronze and not marble. There is actually a type, a sculptural type. You can look. This is a kind of an archaistic, image of Dionysus, the god of wine and theater, with a turban-like, headgear. There are other stone versions that we know of this particular image, but here we have a second bronze, full length, better preserved, and here you actually see this. The phallus I was talking about earlier, sitting there kind of oddly on the shaft. And when it was acquired, it was considered some sort of like later version or cast of that original model, and the museum. And then, but it also, of course, because it had no provenance attached to it, other than came from a dealer in 1979. Was immediately also suspected of being not genuine. In the 1990s, however, the museum, commissioned, and then other people who planned an exhibition on the Madia shipwreck conducted an analysis of the alloy of the bronze of both the Madia version in Tunis, in the Bardo Museum, and the Getty Herm. And it turns out that the alloys are really a very close match, which is you find alloys that match closely in their main components for bronze, copper, tin, then oftentimes lead in this period. But more than that, in this case, there were actually two peaks in trace elements in those bronzes. So these are elements that just happen to be, impurities happen to be in any bronze. In this case, I think magnesium and strontium metals are impurities in the alloy that you do not control for, that the foundry doesn't control for. And the fact that those are, significant peaks that you do not regularly find in other bronzes, this was considered almost too close not to call it actually, the identical metal. And what is the likeliness of that you have two works, two cast from the identical metal, unless it was done in the same workshop from the same batch of metal during the same time. So that's kind of the state of affairs, and it allowed the Getty Museum to change the status, as it were, the date of our Herm to also to the 2nd century BC, and we believe it was part of the workshop that produced this one. And I kind of leave it somewhere open up. This was really, the very workshop of Boethos, but we think of two of them coming from the same workshop. And for the very first time, we showed them side by side in an exhibition that I co-organized a couple of years ago called Power and Pathos, a bronze sculpture of the Hellenistic world. And here we see them side by side. And although in the literature they were often seen side by side, just illustrated like in a book, but they had never been physically next to one another. And I'd like to think about they may have been reunited for the very first time since they left Boethos' workshop, 2,200 years ago. That felt good. Also, importantly now, you see the similar, the ship, the one from the Mahdia shipwreck does have this thing there. I mean, it was just, I'm mystified. I have to actually now research this, why it was missing from this older photo. But you also immediately see, no, you don't immediately see on this photo, but we were able to compare and see more of the differences. And we noticed that the Getty version is a lot less elaborate, and it's lacking in detail compared to this, the signed version. We have found no signature on our Herm. There's like one of these arm bosses is missing on here, so it could have been there, but who knows? So there's really more detail. The hair, this kind of turban thing, is more complicated. It's easy to think of it maybe as a more autograph version, and so we started to think about what's the relationship, what's the chicken, what's the egg, if they really do come from the same workshop, what was first? Was it the elaborate version, and then they decided just to do like kind of more simpler version, that they modified the wax and then do simpler version of an edition that they would sell but make more profit, or was it this was more like kind of a concept thing that was first cast, and then they decided to do a more high-end version of it and give it the artist's signature? Who knows? These questions are still open, but very interesting in this case, because we do not have any other case where we have a bronze signed by an artist and another version of it at the same time that we can compare. Now, at the same year, when the Getty acquired this, their Herm, these two guys kind of rocked the art world. Everybody knows them, the Riace warriors, found at the Riace Marina in Calabria. And when we organized this exhibition on Hellenistic bronzes, many people asked us, so are you going to borrow the Riace bronzes? And of course, these are like some of the most impossible things to borrow, and we didn't. And I had a good excuse because they were not from the Hellenistic period, and they're considered earlier, from the 5th century BC. So I could say I didn't have to. But anyway, what was really what was really extraordinary about this find is that, like, for the first time, scholars in my field, they think of bronzes very much as sort of original artworks. And that's something I have called the paradox, or the kind of the fallacy of bronze, where it's because we have so few, we think of them as sort of the expression of what was original and unique. And we know that many Greek sculptors, worked in bronze, and we know this from the literature from Pliny and others. Whereas we regard the Roman marble versions or copies that were done after some of those original sculptures, we regard those as mere copies, although they are in marble and therefore require actually, being made by hand, as opposed to bronze being the material, obviously, perfectly suited for mechanical reproduction. So that's a bit of a paradox in the field that is still not entirely, eradicated. It's an issue, and the exhibition kind of highlighted our exhibition about Hellenistic bronzes highlighted that. And here, for the first time, with the Riace bronzes, we had two instead of just one, that we can, so what is the original in this case? And if you look at them, they're basically the same. There's like even their fingers are the same, and the only thing that's different is the beards and a bit of their faces. And that tells us already something about like how they must have been made or created using basically molds for different parts, and then they were assembled, and just only with slightly variations you have two different sculptures, but they still basically show to be versions of a common model. Again, some elusive original we don't have. Why is this such an issue with bronze in antiquity? Is because we basically don't have much or any of it, and that's simply because of recycling. Most bronzes, let's say 99.5 or more percent, that existed in antiquity are lost because the metal could be recycled. Easier recycled than throwing marble into a lime kiln. You can still do this. So, but at some point, at any given point in history, the material value of the bronze was higher than the artistic or aesthetic value of the work of art. And here's a great illustration of what this looks like today. This is the, I don't know if you can read the text, this is the ancient site of Olympia, Sanctuary of Zeus. That's actually the entrance there into the famous stadium. The Olympic Games were held, and outside of the stadium are stone bases for the statues of athletic victors. And if you won in an event in the Olympic Games, you would get a statue of yourself erected right there in the sanctuary. And all we have is empty stone bases, but no statues. And sometimes we have names of these people who won. And we actually opened the exhibition with a stone base, much battered, that has actually an inscription here with an artist named Lysippus, favorite sculptor of Alexander the Great in the 4th century BC. And it says Lysippus ep, and ep is truncated here for a poison. Lysippus has made it, so it's like really like the artist's signature. And it would have held a bronze statue, not unlike one also in the Getty Museum. We call it the Getty bronze, but calling it the Getty athlete here. And they would have stood in one of those stone bases, and was probably at some point, that also was found at sea in the 1960s, and it would have been probably ripped from a stone base. And there's actually one in Olympia, or there are others, but that keep some of the, the foot is still on there. These are not related in any way other than I'm just illustrating a point. And so these feet were attached to these stones, but there are cavities, and there's lead is used to connect the bronze, the hollow bronze, to the stone and these cavities. So, and because of the rarity, this is just one of very few of those victorious, athlete statues and of original Greek works of art that we have, that they've really become sort of exponentially higher valued than almost anything else in ancient and particular Roman sculpture. And that also means that whenever an important bronze sculpture is discovered, there is this, I call it a knee-jerk reaction by some scholarly authority who wants to attribute it to one of the famous sculptors of the Greek period. People like Lysippus, obviously, Praxiteles, Polykleitos. So, because those are the ones that are named in the literature, and those are the ones who we have sort of some idea of what their oeuvre looks like, because we have Roman versions, but we don't have any originals of. To make the point about Lysippus, whose empty statue base we saw in the previous slide, I phrased it like a bit like Harper's Index. Number of bronze statues made by Lysippus, according to Pliny, 1,500. Number preserved today, 0. So that kind of illustrates it, and that you see where the desire comes from to attribute works like this one to Lysippus, although it's probably not true. And another case for this is this now pretty much famous bronze version of the Apollosauros in the Cleveland Museum, acquired in 2004, and that is some work that we know through many replicas, Roman replicas in marble, and including this one here in the Vatican on the right. And this one basically has a kind of very sketchy provenance. It doesn't reach back much before the 1990s. But what's interesting is that the museum and the former curator, when they acquired this work, really pushed for an earlier date of it. They didn't want it to think of this as just a Roman bronze version of a famous work of art, rightly attributed to Praxiteles. But since it, and I believe this was sort of, again, the bronze fallacy there, because it was made of bronze, and there's just sort of this one, there's, how should I put it? They wanted, it seemed to be closer to what they thought the original Greek work by Praxiteles in the 4th century BC must have been like. And then they also felt that the quality was so superior that it warrants an attribution to Praxiteles' lifetime. So this was basically declared on, stylistic and sort of connoisseurial ground to be a lifetime cast of a work by Praxiteles, something otherwise unheard of. And I think not very probable, which is why I labeled it more likely a Roman 1st century BC to 1st century AD version. And if we had a lot of other Roman bronze version of it, we would probably not have thought of it as a work that has possibility to be, as the curator put it, from Praxiteles' own workshop. So there's not a problem with bronze. We cannot really distinguish over centuries and periods that well in terms of casting technique, in terms of alloys or other aspects between a bronze that was cast in the 4th century BC or a bronze that was cast in the 2nd century AD. So that really limits our ability to be very forensic about it if we're missing any archaeological context or other provenance. Here's an interesting case where we have to be careful with inscriptions. Or careful, I mean it's tricky with inscriptions. Here's a bust in the shape of one of those herms that is very quickly recognized as an excerpt of one of the most famous Greek sculptures, the Polykleitos of Doryphoros. Exists in more than 100 Roman versions. Here's another Roman version found at the Villa dei Papiri in Herculaneum. Among many bronzes that were preserved there, and an ancient collection of sculpture brought together in the 1st century BC. And that has an inscription on right here. I don't think you can make it out in the photo from the distance, but it says Apollonius the Athenian son of Archias, made it. And it's Greek inscription of obviously a Greek artist who we don't otherwise know, or at least not really clear who he is. The other Apollonius, not a very uncommon name. But Apollonius signed a work that was very obviously, to anyone in antiquity as much as today, recognizable as something created by Polykleitos, the classical bronze caster of the 5th century. And so you start to ask, why is this? Was he just trying to kid, his client? Was he, or was he just getting credit for being the one who made this wonderful cast? Or was he, or is this, somehow the client was happy just to have some work that has a Greek inscription on it, so it gives it sort of like more of a status in his collection of bronzes. We don't exactly know. Polykleitos is not credited anywhere in this inscription. Now, Roman. I think we're. Okay, good. I'll get to the end very quickly. How do Roman sculptors or Roman workshops, or Greek sculptors working in Roman workshops during the Roman period, create versions of the of Greek works that are hundreds of years older? And here's this wonderful phenomenon of ancient plaster casts. There was a cache of those casts, hundreds of smaller fragments and medium-sized fragments, found in Italy near Naples in a place called Baia, that contained those fragments in plaster casts, and they would have been used to make either other bronze versions. So they would have been master copies, or model copies after them with a pointing system. And those, we know that many of those really reproduce Greek works because we have other Roman versions of them. The most famous one is the example of the face of Saint-Gaudens from the Tyrannicides group in Athens, which also only exists in Roman copies. Now, this was just a glimpse to see how was this transmitted. We still have casts of original bronzes, but it is in many cases the closest we get to an original master work. Here's something that then sort of happens in a specialization in the field, which we call copy criticism, is what ancient art historians have engaged with for a long time, particularly German ones. And, briefly, and this has resulted in these kind of what I call sort of exhibition catalogues, Raisonné. I noticed there's one E too many in Raisonné. But so it started with the most famous sculptors, and they were trying to collect all of the copy versions of works for which we do not have originals. So which was very interesting. You would have an exhibition that was full of sort of versions of these elusive originals. And then we tried to decide which ones comes closest to the original, by comparing and analyzing and looking and counting curls and all of this. And I think it even elevated the status of these lost originals even more. So when we have Polykleitos and Lysippus, as I said, we have not a piece of original works of them that we could compare it with. And then, the most recent of those was a Louvre exhibition on Praxiteles. It was interesting because on the cover of the catalogue was a Roman marble, but not in the show was this one work where we can pretty sure what is an original by Praxiteles' hand, the famous Hermes with the infant Dionysus found in Olympia. That was one of those that even the Louvre couldn't borrow from Olympia. And so that would have been the real kick of the show if you had sort of that one original work to be able to compare it to all the marble versions of the Roman period. Yet there are actually, of this very work of the Hermes, there are no marble versions. I conclude with two images back in the exhibition we organized at the Getty and two other venues that highlight sort of that issue of replication and phantom, originals. And one is the case of other these athletes in what we call an apoxiomenous type, an athlete scraping himself off after the competition. And that's a very, very curious case. We have about 12 versions of it, 3 of which is totally exceptional, are in bronze. 2 complete statues and 1 head. And then reproducing, we think, an original of the 4th century BC, but lost altogether. So these are really, again, Roman versions. And here, to add even another twist to this puzzle, are two versions with not of an exactly common model, a similar looking image of an archaistic Apollo, sort of something working in a retrospective style, earlier, hundreds of years earlier, in the Hellenistic period. But those have significant variations. And those, again, those two, and these two, pieces known for a very long time, but had never been shown together. What do we learn from this for our curatorial practice? Is that we needed to bring these rare and often isolated Greek bronzes and Roman bronzes, where we have them, into more of a context in this place. And we used to, and this is a view, again, from this moment in the exhibition, where we had the famous boxer from Rome next to our athlete. And that was fresh in our minds when we prepared these new permanent galleries at the Getty Villa, which just opened a couple of weeks ago. And we placed our athlete who was previously isolated in his own room, in the context of other Hellenistic bronzes, including the Getty Herm of Dionysus that I showed in the beginning, and other bronzes that would have been dedications to sanctuaries. And with this, I would like to thank you for your attention.
We have time for a few questions. Okay, great. Well, I will. Let's just open it up straight to questions, I think, in the interest of moving things along with 3 great presentations. So, yes, please. Yeah, I think a mic is coming if you want to just hold on one moment.
This is for Bill. My understanding was that the actual number of legal cases for authentication is actually pretty small. Is that true or not true?
I think, yes, in objective terms. When you practice in the area, like I do, it takes on perhaps exaggerated significance, but I think for the parties who are stuck in the litigation, they don't think that it's small at all. A lot of times, what is certainly and thankfully small in number are the major, in authenticity cases in particular, the major fraud cases. I represent a plaintiff in one of it was a victim of the Knoedler Gallery scandal, and it's one of the 2 cases that remains ongoing. We are in the middle of summary judgment right now. That case has been going on, for those of you who've been following it, for a number of years now. But that's a major art scandal. There are major art scandals. There have been a couple since Knoedler broke, both in the US and overseas. But if you're looking at it in terms of how many per year, I think it's less than 1 per year, which is good. But when it happens in a big way.
With that case, I mean, it's moving somewhat slowly. Is that what you're saying?
The Knoedler case?
Yeah. Even though the perpetrator admitted that she hired a guy in Queens to make the works?
Well, that didn't happen right away. That took a little time. One of the reasons our case moved slowly is because of the criminal element of the case as well, and oftentimes the civil case will take a back seat to what happens in the criminal case. And then, in this case, Glafira Rosales pleaded guilty. She identified Pei Shen Qian, and everybody sort of sits back and waits to, what else is she going to say? Who else is she going to implicate? At some point that hits its end, and then you go back to the civil litigation. And so in our case, we've alleged that the Knoedler Gallery is a defendant and was in on it. They have alleged that they were the first victim of the fraud, that they were fooled as much as anybody. That's the issue that is being litigated.
Other questions?
I want to reinforce, in a way, jumping off that, how rare it is that specialists who understandably are concerned about getting involved actually will get involved in a suit. I think this is important to underscore. I had an organization, a nonprofit organization called IFAR, that has had an authentication research service for almost 50 years now. Next year will be the 50th year. And during this time, we've involved probably more than a couple of thousand experts, some of whom are members of CRSA, in our process. And I can say absolutely that not one has ever been subpoenaed or sued in those years, nor even threatened with such. So although it's understandable, no one wants to be embroiled in any of these cases, because when you do get embroiled, they really are kind of thankless and can be costly. But the fear, I think, far exceeds the reality of it. And our service still is in existence. It's different from what Bill described for AIA. We're not dealing with arbitration or trying to set that up. We offer it for individuals and organizations and whatever, where there's a question of attribution and authenticity, and et cetera. But otherwise, there's a similarity to the process, and everyone is shielded by an agreement. That's very important, and is shielded from and protected, really. Anyway, separate from that, I did have a question for Bill on the point you mentioned, where you said, I think it was your point 12 in the proposal, that provenance specialists and scientists would be, so to speak, representing the court and not the individuals. So that leaves, of course, the scholars, connoisseurs, but I didn't quite understand at that point what you were describing. So they would remain where each party, because you're dealing in the arbitration with people who are actually in dispute already. It's a completely different step from what I was describing, what IFAR gets involved in. So it would remain where, almost like the Nodla case, really, where expert from party one testifies or gives evidence or whatever, an expert from party two gives the evidence, and they are still sort of, so to speak, responsible for whatever comes as a result of that?
So when you get to connoisseurship, what is contemplated is that the tribunal will reach out to, if there's a foundation or a recognized scholar, to serve as also an expert to the court. That's not something, though, that we can have a pool of experts that you can draw on, because it's obviously artist specific. In the absence of that, the parties would retain their own experts. And then with respect to any number of other issues that could come up, if you have, for instance, a case where, say, Swiss law is controlling, and you don't have Swiss lawyers as arbitrators, the parties might want to have a Swiss legal expert. And then it would be a traditional model. Both sides would have their own experts. Damages, parties could have their own damages experts. So it's not that every issue that requires expertise will involve an expert to the court. But for the areas of forensics and provenance, we believe that we will be able to identify internationally people who will be willing to be part of a panel or a pool that can be selected on any given case, and their skills are basically fungible by medium and by artist and by time period.
Thank you.
If I could just bring it back specifically to the problem of sculpture that we've been discussing for 2 days now, where we don't even have terminology for original, reproduction, copy, version. Are you thinking in that direction? I mean, it's much more subtle than good or bad, fake or authentic. How are you going to deal with this very complex issue that we've been
So to be candid, I personally have not litigated a sculpture case, and I can't speak to the nuances that you're describing, but we will have, the hope at least is that you will be able to select from among the arbitrator pool lawyers who can identify that they've had some familiarity with sculpture art cases. In the absence of that, then you would have, at least you would have art versant lawyers as your arbitrators, and then you would want to have the right experts. If forensics, for instance, are important, you'd want to have somebody who has experience dealing with sculpture art. But it will be, it's not necessarily customized that way. And I'm sorry that I personally can't speak to it right now.
One last question. Why can't they unseal the plasters, the molds? Sorry.
That's because we're a museum, we don't want to destroy the objects that we're caring for.
The plasters from Bahia, has it been established what they were actually made from? I think you mentioned from bronzes, but...
Well, I skipped over a detail. If you maybe recall the image of the drapery fold that I had at the left, and it had the edge, had this kind of very crimped kind of edge. It's very fine undulations, which is one of the, among other evidence that these plasters were taken from, we believe, bronze sculptures. Right. In other cases, you can't be all that sure, and most of the material, I showed you some of the best preserved, most of the material is broken down into much smaller, fragments, which didn't keep, scholars to attributing it to particular statue types. But it is the belief that it is actually a set of plasters that were taken either really from the original works, or are very close to, in terms of maybe they're what you call sumolages, or like second generation casts. But otherwise, but this is a bit. There's no proof for this. No. There's nothing substantial enough. Although there are hundreds of them, there's no proof. It's like we know that this was taken exactly from the work that is the autograph work by Polykleitos, that stands in that stood at the time still in that sanctuary somewhere in Greece. Mm-hmm. But there must have been. It just shows to illustrate the transmission of these models across the Mediterranean.
Thank you.
Actually, I have a question for you, Bill. I have a chance to get some free legal advice.
And everyone else.
Which is, at a conference like this, if I were to give a talk in which I were very critical of certain people in terms of the way in which they handled posthumous casts, violated ethical norms, could I be sued?
So you can always be sued. The answer to that
Okay.
question is yes. In this country, you would look first to the First Amendment. And the first line of defense, you'd be sued for defamation, basically, or slander, spoken defamation. And so your first defense is going to be, I wasn't speaking a fact, I was just speaking my opinion. And opinion is protected, is absolutely protected. The difference would be if you got up and said, I was with this person and I saw them, disregard ethics rule 1-24 and say, I don't really care about that rule. And now you're speaking factually. And that is what's leading to your statement that I think that they've acted unethically. Then you potentially might be sued for defamation because you're not just speaking your opinion, you're speaking a fact that is not publicly available, publicly verifiable. You're basically saying, trust me. And if you're lying about that, then you could be liable.
Okay, so if I were a British subject and I made comments like this in the United States, am I protected by the First Amendment?
Okay, so now you're welcome to second-year law school. We've skipped first. You've implicated issues of not only choice of law but jurisdiction. You've implicated issues of venue. The Constitution applies to U.S. citizens, and particularly our current Supreme Court has been very sort of has narrowed when U.S. citizens have the right to sue foreign countries or companies, and equally, I think when foreigners would look to rely on U.S. protections. I don't know off the top of my head whether there's some case out there that says that a British subject who is on U.S. soil speaking opinion, getting sued for that, would be able to avail her or himself of the First Amendment of our Constitution when they're not a U.S. citizen. My instinct is not, but I don't know if that's been a particularly litigated issue.
Okay, thank you.
Sure.
You had, okay, one more question, and then we'll do the quick wrap-up that we mentioned earlier.
What is, maybe I'm stepping ahead already with a little wrap-up. I'm Lynn Rother. I'm overseeing provenance research at the Museum of Modern Art. So I do have to thank you, I think, not only on my behalf, but also on all the other MoMA colleagues that were here over the days for how many insights you gave to works in our collection, but also to general questions. Taking advantage of that, there are also lawyers in the room, and of course provenance research and Catalogue, Raisonné and casts have a lot of intersection and overlappings. While I would at this point out, because the parallel is that for the cast issue you don't have terminology, we have the same in provenance. Is something removed, is something sequestered, is something seized, is something confiscated. And now going digitally, of course, terminology becomes even more important. How do we actually then find objects that are technically from the same transaction, for example? So I was thinking of, well, that's why I was at the Getty, so also Jens is here from the Getty Museum, but the Getty Research Institute has in fact the AAT. And I'm not sure if someone has looked at it, there's no, at the moment there is no entry for surmoulage, but there is one for version, there's one for copies, and there's one for original. And of course, the Getty, the GRI in that case, the Getty Research Institute with their Getty vocabularies, sees themselves not necessarily as the how do you call it, the authority for the content, because all contributors can provide information. So I wonder if all these amazing talks and also the knowledge, if the right place for maybe also compiling that could be something like the AAT, that then also lesser equipped scholars in that specific field can still use the knowledge. And as I said, the same is with provenance. It would be great to have the same terminology. Not everyone is an expert in all the legal cases. And that also, that's why I mentioned with lawyers on the table, is like, I do think that the lawyer's input is actually necessary for art historian thinking of how do we define that. You have sometimes more distance and see a bigger and abstracter picture. And it still allows, also the AAT at the Getty allows that, for example, someone, the preferred word would be looted, but MoMA wants to call it seized. So it does allow all these layers, and that's what I think with the terminology for casts, etc. If it only wins by contributors with the absolute expertise. So thank you for. So thank you, Sharon, and thank you, Katy, for.